Fundamentals of our argument on why we say a compliant construction is possible. And it really boils down to three submissions. The first is we say the result to be achieved by Article 11 is clear. National law must provide real and effective protection against the sanctions identified in Carasay. And if there's any uncertainty about that test, it's resolved, we say, by the ILO C98 and the European Social Charter, which, as we know, have repeatedly been used as a point of reference, by which there must be protection against, quote, any harmful consequence or any prejudice to a worker by participation in trade union activities. Those are, I'm echoing there the citations in Danilenkov, paragraphs 102 and 7, which we've already looked at, but for your note, EF 889 and following.
102 and 107, did you say?
102 to 107. So that's the first point. The result is clear to be achieved. The second fundamental point is that we will say that in almost all cases, Section 146 and Part 3 is already in harmony with Article 11. Part 3 is about protecting the freedom of association that Article 11 guarantees. And so, for example, it guarantees rights required by Article 11 in relation to refusal of employment, see Section 137, unlawful inducements, Section 145A to F, and Section 146 itself. In other words, Part 3 already protects against the unlawful detrimental treatments which we've seen in the Strasbourg cases. It protects against the sort of detrimental treatment in Straum, the unlawful inducements in Wilson, the closed shop arrangements in Young, James and Webster. And in the case of, this is still part of my second submission, in the case of Section 146 in particular, it extends to any detriment, which we say mirrors perfectly what Strasbourg requires, as shown by the references to Article 5, ESC and ILO 98. It applies a sole or main purpose test, which we say is compatible in accordance, chimes with the approach taken by Strasbourg to sanctions imposed owing to trade union activities under Article 11, intended to dissuade. And it chimes too with Article 5 of the European Social Charter, which talks of because of trade union activities, and with ILO C98, which talks of by reason of. And equally, just like Strasbourg, the protection of Section 146 isn't restricted to the formal right to hold a membership card. So it extends to preventing, deterring or penalising workers because of membership, using trade union services, or taking part in trade union activities. So it already protects against a very wide range of the detriments which Article 11 requires protection for in harmony. When it comes to industrial action, Section 146 already protects a worker being subject to a detriment because he or she was involved in the planning or organising of industrial action, so long as it takes place outside of working hours. And for that, I haven't got time to go to it, see Brittle and Roberts, EF 1473, when it was held that dismissal for leading the strike was an unfair dismissal because of trade union activities under what was formerly Section 58 of the 1978 Act. So Section 1452 and Section 146 both protect against that. And equally, if a worker is subject to detrimental treatment, which is a breach of contract because of their protection in industrial action, they may resign and claim constructive dismissal, in which case that may be automatically unfair under Section 238A. So that's another way in which detrimental treatment because of participation on a strike is already protected by the domestic regime. So thirdly, we say the grain, if you like, the thrust of Section 146 and Part 3 is very much in favour of a compliant construction. And what we say is you can nudge the provision over the line and protect not only the planning and preparation for the strike, but the actual participation in the strike. We say it's just an extension of the reach of the provision, to echo Lord Roger in Gaydon, paragraph 128, EF 493. My Lords, on the principles, my Lords and my ladies know them better than I do. And everyone knows Gaydon, but they are, we say, summarised in our case at paragraphs 62 and 64, EF 86, and by the EAT at paragraph 70, EF 209. I'm not going to go to any of the speeches in Gaydon, save to ask the court to do something slightly unusual, and that is to read Lord Millett's dissent. Once more, I don't have time to turn to it, but it's at paragraphs 78 to 100 at EF 478 to 483.
Sorry, reference again?
Paragraphs 78 to 100 at EF 478 to 483.
Sorry, the electronic reference.
478 to 483.
Thank you.
Now, the reason why I'm asking my Lords and my Lady to read it is because he explains very carefully and thoroughly why, first of all, the clear language of Schedule 1 to the Rents Act 1977 counted against compliant construction. Secondly, he looked in detail at the legislative history and said, look, this provision has been considered by Parliament over the years. At one stage it applied to widows. Subsequently it was extended to spouses. Subsequently to that it was extended to people living as husband and wife. There had been consideration of Parliament by it all over the years, but it had never been extended to same-sex couples. And finally, he raised various policy questions. You'll see those at 98. And the reason, obviously, I'm asking this to look at that is because it shows, by contrast, just how powerful the interpretative obligation was in Section 3, because despite those arguments, the majority said you can do it. And as another example, we rely on Sheldrake and Lord Bingham's summary of the principles at 28, paragraph 28, EF 809. But we also rely on what the court actually did in Sheldrake, because there, again, the legislation listed the provisions under the Terrorism Act, which imposed an evidential burden. That's paragraph 50, EF 818. So section 711 wasn't listed in the relevant provisions, but again, nonetheless, Lord Bingham considered there was no problem in interpreting the section only to impose an evidential burden, even though it wasn't specifically listed. So those are all I want to say about the principles. And we have summarised in our case 5 points on purely domestic construction at 69 to 74, EF 88 to 90. Which I won't repeat here. So that brings me on to the grain or the thrust, which of course is relevant to Mr. Stillett's point that our interpretation contradicts a fundamental feature of the legislation. And we say, well, fundamental feature, grain, thrust, whatever metaphor you search for, these are all part of answering the same question. And we say whether you talk about grain, thrust, cardinal principles or fundamental features, the thrust of these provisions, firstly, is to protect freedom of association. Secondly, recognises that a lawful strike is a legitimate trade union activity. And thirdly, across history, these provisions reveal a thrust or grain to comply with Article 11. We see that because the original thrust of this provision, its common ground on this was to comply with ILO C98. You can see that in the Donovan Commission report. Can I just give you the references? That's paragraphs 242 to 246 at EF 3053. Where they noted that under the convention, quote, the government undertakes that the country's laws and practices will conform with it, meaning that convention. The very convention which protects workers against being subject to detrimental treatment for going on strike. And secondly, so that was the original boost, and then we get a further boost in 2004, when, as we can see from the response to the consultation, which some members of this court dealt with in Coastal, the government said it intends that the legislation as a matter of principle should comply with the European Convention. See, or that, paragraph 3.9 of the consultation paper, EF 3050. And finally, we say that the special rules on industrial unfair dismissal in Part 5 have always been particular to that particular statutory remedy, including prior to the 78 Act being in separate acts. So when you went before the 78 Consolidation Act, you had protection against short of dismissal in one act and protection against dismissal in another.
Only for a year, though.
Yeah. So it's against that background that we turn to the Court of Appeal decision. And they didn't...
Just remind me where your suggested, in a sense, interpretation is.
Yeah.
It's in your skeleton, it's in your statement of
Yeah,
case.
it's actually misquoted in the Secretary of State's case. It's in our case at paragraph 93. Yes, I'm grateful. So it's to mould the definition of an appropriate time to include that subparagraph C. And my Lord, the purpose of that, we've defined it as protected industrial action, which is critical, and that's the word that the Secretary of State misses out. The reason why that is that then means it's the same as the concept of protected industrial action in section 238A1, which means it must be lawful as a matter of domestic law.
So the definition of appropriate time would be different in 146 and 152.
Yes. Yes, we accept to that extent there's a dissonance, but we say that's not a sufficient reason for not taking the incremental step of bringing section 146 into compliance. Because as you'll see, our amendment is restricted to detriment short of dismissal. Our interpretation, I should say. And it's restricted to protected industrial action. And that means it has to comply with all the substantive and procedural rules under domestic law.
But you would accept that that is a major problem for your case, presumably. Maybe you can overcome it, but it would look very odd, wouldn't it, to have a different interpretation of appropriate time in 146 and then a completely different one or significantly different one in 152.
Well, we accept it's a linguistic obstacle to us. We accept it creates some dissonance in the statutes. Of course we do. But we say these are effectively domestic rules of interpretation, presumptions that the same words have to be the same meaning, that some imperfection shouldn't or isn't a sufficient reason for not taking what we've described as the incremental step of bringing section 146 into alignment.
But it makes it quite difficult to then say you're going with the grain of the legislation. You produce that sort of...
As you'll have seen from our case, we rely on Hurst, where Hurst says you interpret the same provision differently when it comes to where Strasbourg rights are engaged from how you interpret it when they're not. That's the same provision. We say that applies yet more strongly in this case. You're entitled to interpret section 146 differently from section 152 in order to ensure compliance with Strasbourg rights. And I should say, of course, we're not saying that the issue of compatibility of section 152 and the like isn't before you, but I can see there'd be an uphill struggle faced with 152 because you'd say, well, there's a specific regime covering this. You can't have a duplicate remedies. But in the case of 146, there are no duplicate remedies. Unless you there are no other remedies. Section 15, in the case of dismissal, there are a variety of unfair dismissal remedies given by the statutory regime, which may and often will be compliant with Article 11. In the case of Section 146, you have none. So against that background, can I turn to the Court of Appeal judgment? And if I can pick it up at EF 178. Paragraph 72. And the first reason the Court of Appeal gives is they say at 72, the complaint is not there is something in section 146 which possibly offends Article 11, but rather that it and the legislation taken as a whole fails to accord adequate protection. But that's never been our argument. Our argument has always been that there's an apparent incompatibility between section 146 as conventionally interpreted and Article 11. So we perhaps that's another paragraph we say is enigmatic because we don't understand that point.
Sorry, which paragraph is that in?
72. We've never said it's the legislation as a whole. We've always said it's the specific barriers in section 146 as conventionally interpreted which cause the problem. Secondly, the Court of Appeal then at 74 said, well, what types of industrial, what are the policy, one of the policy questions here is what types of industrial action are protected? Should it be all or only official?
That point's fallen away now because
Yes.
you've conceded.
Yes, but it had fallen away anyway in the Court of Appeal because we presented the same amendment in the Court of Appeal. So we accept that only official strikes called by a union in defence of the members' occupational interests are protected. Barris. We accept that only lawful strikes are protected. RMT and Trofimchuk. But once Parliament has circumscribed what is lawful industrial action, Article 11 says you can't attack individuals who are within that perimeter. So we say that problem evaporates in light of the result required by Strasbourg. The second policy issue that the Court of Appeal raised at 75 was to say, well, how long must the protection extend under Article 11? Saying that it would be very odd if the protection under industrial action of unfair dismissal expires after 12 weeks. Well, and it would be odd if the protection under under Section 146 was longer. Well, the first point to note there, of course, is that the protection of unfair dismissal under Section 238A isn't restricted to 12 weeks. My lords and ladies will recall the explanation at the start that it can be, in fact, it can be unfair dismissal under ordinary principles if you dismiss people before they've started striking. But again, the extent of those protections isn't the issue before the court, nor whether the gap could be enclosed if there is a discordance between Article 11 and Section and the unfair dismissal protections. But we say when it comes to sanctions short of dismissal of the type considered in Carasay, it's crystal clear from Strasbourg there is no time limit on the extent of the protection. If you did, it would contradict the underlying principle that strikers aren't to be subject to unlawful detriments intended to dissuade or penalise them. So we say that isn't a point, a real point about Article 11, because the result to be achieved by Article 11 is clear there as well. And then thirdly, at 76, the Court of Appeal said it's far from obvious that Article 11 requires protection to be given against every form of detriment, at any rate in a private sector case. Well, I've already dealt with that really in what we've said so far. We say this is, the principles from Strasbourg are clear on this, that any sanction intended to dissuade or penalise in a lawful union organised strike is not permissible. So we say that problem too evaporates because the result required by Strasbourg is clear. My lords and my lady, given
on
the
your
time,
paragraph 75 point, I mean, does it follow that logically that you say that the 12-week limit in 238A itself contravenes Article 11?
well, we would say, and I've already mentioned the European Committee of Social Rights has said it's arbitrary and can't be justified, and it's also, so if that point arose,
Yeah.
but then of course you'd be faced with a different interpretative question, because you would be facing a different regime, and the issue would be, well, can you interpret that 12 weeks away?
I see.
And I can see that would be a...
Right. But insofar as it applies to, at any rate, to union members who are dismissed, you know, it must be the logical consequence of this argument that 238A is not compliant with Article 11.
It would be, my lord, yes. So given the short time available, can I then turn to Section 4, the Section 4 declaration? And again, I'll try and be brief on this, and the arguments fully set out in our case, but can I just explain what happened below? The Secretary of State below didn't oppose the granting of a declaration. And we say that may be one of the reasons why, with respect, the Court of Appeal went badly wrong in this aspect. And if I can start with the judgment itself at paragraph 82. So the premise of the Court of Appeal's judgment, again, was that the declaration we were seeking should not be directed so much at Section 146 as Tulka as a whole. And then you can see at 84 to 5, they applied res by analogy. That was the case about the starred system in care proceedings, and referred to Lord Nichols' judgment that failure to provide an effective remedy for a violation of Article 8 is not itself a violation of Article 8, saying that was similar here. And then thirdly, relied on comments in Bellinger and Bellinger, directed to Section 3 of the Human Rights Act, to conclude it couldn't grant a declaration in what it described as a lacuna in the law. So those are the three steps in its reasoning, and we are genuinely perplexed by the reasoning and its premise. And we submit this may be a reflection of the point that the Secretary of State conceded this in the before the Court of Appeal. So there wasn't really any substantive argument on the points. And matters such as re-S, for example, were never raised with us by the Court of Appeal. Now, I won't repeat what is in our case, but in summary, we say when it comes to approaching a declaration of incompatibility, firstly, there is the general purpose of the Human Rights Act of bringing rights home, reflected in the White Paper, which we say is a strong factor against reticence in using the Section 4 power. See especially paragraphs 1.14 to 1.18.
(1.14 to 1.18)
in the White Paper and 1.17 at EF 1067. And in the White Paper, the government noted that the road to Strasbourg is long and hard, and it's now longer and harder. I don't know what the current delays are in courts' judgments. But the purpose behind the Section 4 declaration, of course, was for matters to be dealt with in the English courts and in the English legislature, not going to Strasbourg. Secondly, there's the emergency remedial power in Section 10, by which the government can pass emergency remedial legislation, which we say is a further powerful factor counting in favour of a declaration. Thirdly, the authorities suggest that it will be an unusual or exceptional case where there's an incompatibility but not to grant a declaration. See, for example, Nicklinson on assisted suicide, which I won't begin to try and summarise the ratio at this stage in the afternoon. I think Lord Reid described it as elusive in one case. And fourthly, we rely on the leading text, De Smith and Lester, Panic and Herberger, just to give you the references, EF 3034 and EF 3038, which all suggest it would be a rare case where a court finds an incompatibility but doesn't grant a declaration. So against that background, can I deal with each of the points raised by the Court of Appeal? So the first reason was said to be that we were complaining that Tolka as a whole was incompatibility. It was incompatibility. There was a general lacuna. In relation to that, we make 3 points. Firstly, this is an inaccurate characterisation of Mrs. Mercer's complaint. It was and has always been that it is Section 146 specifically which is incompatible with Article 11. See the Court of Appeal, paragraph 49 at EF 170, summarising our submissions. It's that provision which provides for her Article 11 rights, including the planning of industrial action, and it's that protection which is intrinsically incompatible with Article 11. Secondly, and this really echoes that same point, there are 2 positive barriers on the conventional interpretation of Section 146 to achieve incompatibility, namely the exclusion of participation in industrial actions in light of the parallel provisions in Section 152 and the definition of an appropriate time. Thirdly, we say the Secretary of State's case on this is internally contradictory. On the one hand, they say Parliament has chosen to define an appropriate time precisely in order to exclude industrial action. See, for example, their case, paragraph 9, EF 113, paragraphs 46 and 47, EF 124, and paragraph 102 EF 148. But on the other hand, they deny there is a specific barrier or element in section 146 which offends against Article 11. So we are genuinely perplexed on this point, because there is only one plausible candidate for the Section 3 interpretation. That is Section 146. The second point relied upon by the Court of Appeal was an analogy with Re S. Now, we deal with this in our case at 112 to 113. I only have time to give headline points. But we say the key steps in Lord Nichols' speech in Re S were the following. Firstly, paragraphs 56 to 7. If the local authority acted properly, there would be no violation of Article 8. Secondly, he was addressing an argument raised by one of the claimants that if the local authority acted improperly, there would be no sufficient remedy for breach, and therefore that hypothetical example meant there was an infringement. In other words, the argument was, if the local authority did act improperly, there wouldn't be an effective remedy. But all Lord Nichols was saying in the critical paragraph at 59 was you can't win on that sort of bootstraps argument. You can't just say, if hypothetically Article 8 was breached, I wouldn't have an effective remedy, and that is a breach of Article 8. So all he was saying was the truism that the absence of a remedy for a hypothetical breach was not itself a breach. And we say this reasoning has, with respect, nothing to do with our case. We are not saying the breach of Article 11 arises from the absence of remedy for a hypothetical breach. Rather, we are saying there is an actual breach of Article 11 on the assumed facts, and we do not have a substantive right under domestic law to protect against that breach. So it's about substantive right, not remedy. And finally, the reliance on Bellinger and Bellinger, which the court relied upon for refusing a declaration in 86. And here too, we submit they've used Bellinger and Bellinger for the wrong purpose. Because the Court of Appeal relied on Lord Nichols' comments in Bellinger for refusing to interpret the Matrimonial Causes Act so as to extend to allow transgender people to marry. But that had nothing to do with the actual Section 4 declaration, because in Bellinger, despite the great practical problems that would arise, uncertainty about where the line would be drawn, which individuals were to be protected, and so on and so forth, the court granted a Section 4 declaration in Bellinger. So we say that the policy reasons for barring a Section 3 interpretation are very poor reasons for refusing a Section 4 declaration. It ends up being contrary to the remedial structure of the Human Rights Act of bringing rights home. If the reasons counting against a Section 3 interpretation are equally relied upon to refuse a Section 4 declaration, you're effectively depriving Section 4 of any substance. Because you'd say we refuse Section 3, therefore we refuse Section 4. And it would cease to add anything for Section 3. So we say the reason the Court of Appeal went, with respect, badly wrong in relation to Section 4 even if there are policy choices, the whole purpose of a Section 4 declaration is to enable Parliament to resolve them, just as it did in Bellinger, where they're far more acute than here. And none of these reasons is sufficient to overcome the overriding purpose of Section 4. And I should just add by saying the Secretary of State doesn't say that if the Court of Appeal got it wrong, its judgment should be upheld for different reasons. The Secretary of State simply said the Court of Appeal got it right. So we submit that if, as we've argued, the Court of Appeal got it wrong, then properly this court should issue a Section 4 declaration. Thank you very much, my Lord.
Mr. Ford, could I just ask you this? If, for one reason or another, it was inappropriate for the court to grant a declaration under Section 4, would it be open to the court to make a declaration at common law?
My Lord, I don't. I haven't looked at the principles on a common law declaration, and I'm aware they're not straightforward.
You might like to.
Is that something we could
You might like to
look at and address if necessary?
Is there anything in it you might like to come back on that when you deal with it in reply?
Yeah. But at the moment, my Lord, I wouldn't want to give an off-the-cuff remark, which is almost certainly wrong.
Thank you very much. Thank you, Mr. Ford. We're grateful. Mr. Sellers.
May it please your lordships and your ladyship, in this court, Article 11 cases are a bit like buses. You wait years for one to come along, and then we have two within, 2 weeks ago, judgment delivered in Deliveroo, and now we're back on Article 11 already, so an embarrassment of riches. In my submissions, I propose to make them under the following headings. Very briefly, to say something about the facts. Secondly, to deal with the legislative scheme. Thirdly, to deal with the case law on Article 11. And with that, the first ground of appeal. Fourthly, the argument for reading down under Section 3. And fifthly, the argument that the court has just been considering in relation to declaration of incompatibility under Section 4 of the Human Rights Act. Before doing so, I should just briefly outline the Secretary of State's position, which is, first, that Article 11 does not require that the state should put in place universal protection of workers from detrimental action by their employers in response to industrial action. Secondly, that the current statutory and common law rights and protections afforded to trade unions and their members in respect of industrial action have established a regime which is compatible with Article 11, bearing in mind the wide margin of appreciation which the state has in determining how to balance the competing interests of employers and workers. Thirdly, even if the current statutory regime were incompatible with Article 11, Section 3 of the HRA can't assist the appellant because it's not possible to read down the legislation here without making important policy choices. There are a wide range of approaches which might be taken to legislating in this area, and each way of doing so strikes a different balance between the interests of employers and workers, and there is no way of avoiding this descent into the legislative arena. Moreover, we submit that to address any perceived shortcoming through interpretation would cut across certain fundamental features of the legislation. And finally, we say that Section 4 of the HRA is not in play, essentially because there is no specific statutory provision here which can be said to be incompatible with Article 11. So with those preliminary submissions, I turn briefly, very briefly, to the facts which can be taken most easily from the Employment Tribunal's judgment at EF, so page 220 in the electronic bundle. And we can pick it up at paragraph 7 of the Employment Tribunal's judgment. In early 2019, there was a trade dispute regarding payments for sleep-in shifts. The union called a series of strikes, no attempt to seek an injunction. And then at 8, the claimant was involved in planning and organising the strikes. In that capacity, she was interviewed by an online publication, iNews, in January 2019, and some press material appeared in the Liverpool Echo in late March 2019. She also intended to participate in the strikes herself. On the 26th of March 2019, the claimant was suspended. The respondent told her it was because of allegations she'd abandoned her shift on 2 separate occasions without permission, and that she'd spoken to the press about the strike action without prior authorisation in a way which conveyed confidential information and was considered likely to bring the organisation into disrepute. And then at 10, the suspension was lifted on the 11th of April 2019, but the disciplinary matter proceeded. On the 26th of April 2019, the claimant was given a first written warning for leaving her shift. That sanction was overturned on appeal. So that was the course of events, and her grievance was rejected. And if we could turn very briefly to the suspension letter itself, because it's really the suspension that's the burden of the allegation of detriment here. That's at page 122 in the electronic bundle. Dear Fiona, I'm writing to confirm the details of your suspension from duty on full pay with effect from 26th of March 2019 due to the following allegations being made against you: bringing the reputation of the organisation into disrepute, breach of social media policy and abandonment of shift. Your suspension from duties is in accordance with the Alternative Futures Group disciplinary procedure.
Sorry, we haven't got the reference.
I'm on the wrong, it gave us 122, I think.
122 in the... Oh, I'm so sorry. It's got 2 page numbers. The correct one is 277. I apologise.
Thank you.
277. I do apologise. So it's dated the 27th of March 2019. Suspension from duties. I'm writing to confirm the details of your suspension on full pay.
Yeah.
Bring the reputation of organisation into disrepute, etc. Then your suspension from duties is in accordance with the Alternative Futures Group disciplinary procedure. Suspension is a neutral act and is not a disciplinary sanction. Suspension is invoked to enable an investigation to take place without prejudice, protecting the interests of all affected parties. So I turn to the facts only because the appellant puts her case very high, we submit in this case, by saying that any detriment in response to participation in a strike or industrial action which is unremedied will inevitably involve a breach of Article 11. And although we don't suggest that the suspension was not detrimental, it's fair to say that on the facts of this case, this was a relatively minor detriment in circumstances where ultimately no disciplinary sanction was upheld. So that's all I wanted to say about the facts. Turning then to the legislative background. We set out at some length in our case the relevant provisions which have evolved over the last 52 years. To make good what we submit ought to be a relatively uncontroversial point, namely that sections 146 and 152 should be are what I describe as sibling provisions with a parallel legislative history which should be read, if possible, in a congruent way. And we took the Court of Appeal through that history to seek to rebut the finding of Mr. Justice Chowdhury in the EAT that he found that those provisions had developed separately. In fact, we submit they developed in close parallel and have been treated by Parliament as complementary provisions. I won't take the Court through all of that history, but I would like to go to some of it. And I'd like to start, perhaps slightly unusually, with the ILO Convention 98, which its common ground lay behind this legislation in the first place. And that's at page 409 of the bundle, tab 4 in the authorities. Now, this was a convention dating from 1949, and we see in the middle of the page Article 1. Workers shall enjoy adequate protection against acts of anti-union discrimination in respect of their employment. 2. Such protection shall apply more particularly in respect of acts calculated to A. Make the employment of a worker subject to the condition that he shall not join a union or shall relinquish trade union membership. B. Cause the dismissal of or otherwise prejudice a worker by reason of union membership or because of participation in union activities outside working hours or with the consent of the employer within working hours. And so one can see that the origin of sections 146 and 152 are evidently there in the terms of Article 1 of ILO Convention 98. And one will see that under Article 1.2b, the right not to be dismissed or subjected to detriment is specifically linked to the time when union activities are undertaken. And the explanation for that qualification is that the article, while protecting trade union activities at an appropriate time, was not intended to protect workers who engage in strike action or other action which directly disrupts the employer's business from being subject to detriments. If that had been the intention, the reference to the time at which activities take place would have been wholly inexplicable.
Participation in union activities is one specific example of a more general provision here, isn't it?
Yes, I accept that, but I don't rely on it for anything more than to see the origin of the provisions we're looking at. I also make the point that it's striking how closely the terms of Article 1.2b are in accordance with sections 146 and 152 and the reference to an appropriate time that we now have. Now, that provision was taken up in the Donovan Report of June 1968, the Royal Commission on Industrial Relations, which led to the Industrial Relations Act 1971. And I would like to go to that piece of legislation, if I may. It's tab 41, page 1295 in the authorities. The relevant provisions are in Section 5 of the Industrial Relations Act 1971. Subsection 1, every worker shall, as between himself and his employer, have the following rights. And then at C, where he is a member of a trade union, the right at an appropriate time to take part in the activities of the trade union, including any activities as or with a view to becoming an official of the trade union, the right to seek or accept appointment or election. At subsection 2, it shall accordingly be an unfair industrial practice for an employer or for any person acting on behalf of an employer to prevent or deter a worker from exercising any of the rights conferred on him by subsection 1 of this section, or to dismiss, penalise, or otherwise discriminate a worker by reason of his exercising any such right. So we have section 146 and 152, the origins are there in the Industrial Relations Act. And importantly, subsection 5 on the following page, 1296, says, in this section, appropriate time in relation to a worker taking part in any activities of a trade union means time which either A, is outside his working hours, or B, is a time within his working hours at which, in accordance with arrangements agreed with or consent given by on behalf of his employer, it is permissible for him to take part in those activities. And in this section, working hours in relation to worker means any time when, in accordance with his contract of employment, he's required to be at work. So that's the first enactment, 52 years ago now, of the provisions that we're now concerned with. I won't take you to it, but there were also separate provisions dealing with dismissal for taking part in strike action. And what we see is throughout the history of this legislation, there have been two sets of provisions. First, provisions dealing with protections relating to participation in union activities, and separately, protections relating to participation in strikes and industrial action. We set that all out in our case, and I don't take you through it. So it goes through the Trade Union Labour Relations Act 74, the Employment Protection Act 75, then the Employment Protection Consolidation Act 1978. There is, at that point in the legislative history, the helpful case of the EAT in Drew and St Edmundbury. If we could quickly look at that. That is at page 446 it should be at, although we have the new version of that in the ICR, so there may be an issue. That was what came in belatedly today, or at least more recently. But if you have Drew and St Edmundsbury, it's at tab 8 in the, that's not right, it's at tab 7 in the authorities bundle.
Yes.
And it just draws very vividly this relevant distinction. The head note says an employee, a trade union member, was dismissed after less than 26 weeks. On his complaint of unfair dismissal, for complaining to his employers about health and safety standards. On his complaint of unfair dismissal, an industrial tribunal found, although the employee purported to be following a union directive to go slow, the directive was not concerned with health and safety matters, and he was not dismissed for taking part in the activities of a trade union. They held that he was dismissed for taking part in industrial action, which could not be a trade union activity, and that since he had not been continuously employed for 26 weeks, they had no jurisdiction to hear the complaint. Dismissing the appeal, the Industrial Tribunal's conclusion that the union directive was not concerned with health and safety standards, that the employee was not dismissed for taking part in union activities, was supported by the evidence that there was a distinction in the 1978 Act for the purposes of unfair dismissal between dismissal for taking part in trade union activities and a dismissal for industrial action. And we see the relevant part of Mr. Justice Slynn's judgment at page 517 in the ICR report, below letter E. The tribunal finally decided the appeal failed for an alternative reason. They considered that there was a distinction between the activities of an independent trade union and taking part in a strike or other industrial action. It was their view that what happened was taking part in industrial action, then it could not be a trade union activity for the purpose of Section 58 of the Act. That view of the tribunal, which Mr. Tabachnik supports in argument before us, is based on a contrast between Section 58 and Section 62 of the Act. Under Section 58, if an employer dismisses because a man has taken part in the activities of an independent trade union, then the dismissal is unfair. Under Section 62, if an employee takes part in strike or other industrial action, the position is entirely different. There, a man is not entitled to bring a claim that he's been unfairly dismissed. that he's not been unfairly dismissed when at the date of the dismissal he was taking part in a strike or other industrial action, unless he can show that other employees who, to put it broadly, were taking part in industrial action were not dismissed at the same time, or if some were offered re-engagement and that he was one who was not. It is quite impossible, it seems to us, and as Mr. Tabachnik submits, for the same person to fall under both of these sections. Accordingly, it seems to us quite clear that it was intended by Parliament to be a distinction for the purposes of a claim of unfair dismissal between what is an activity of an independent trade union and taking part in industrial action. It seems to us that that distinction is borne out for the purpose of legislation when one considers the terms of Section 23 and Section 28, which are dealing with trade union membership and activities and time off for trade union activities. We do not find it necessary to set those sections out in detail. Suffice it to say that it seems to us they support the distinction. And in our submission, the Court of Appeal in this case was quite right to follow that analysis, which is plainly borne out by the legislation itself. And on that note, I would like to take this court directly to the 1992 Act, which is the legislation with which we are concerned. And that is at tab 1 of the authorities bundle. It begins at page 284 of the electronic bundle. And if we could go first to page 300, which is section 146 itself. 146, detriment on grounds related to union membership or activities. And subsection 1, this right applies to a worker, so not only an employee but a Limb B worker as well. That was an amendment affected by the Employment Relations Act 2004. A worker has the right not to be subjected to any detriment as an individual by any act or any deliberate failure to act by employer if the act takes place or the sole main purpose of preventing or deterring him from becoming a member of an independent trade union, preventing or deterring him from taking part in the activities of an independent trade union at an appropriate time, or penalising him for doing so, and so on. And it is Limb B that we're concerned with. While we're at section 146, I would refer the court to subsection 5A, which is over the page at 301. This section does not apply where A, the worker is an employee, and B, the detriment in question amounts to dismissal. And one can see there that Parliament was seeking to create a congruent code between section 146 on the one hand and section 152 on the other, because 152 is the provision which deals with dismissal in the case of an employee for taking part in trade union activities at an appropriate time. The effect of this is that a worker, a Limb B worker, can make a claim for detriment if they are dismissed for taking part in trade union activities at an appropriate time. And the significance of that is something we will come back to. Turning next to section 152, what we describe as the sibling provision, there we have dismissal of an employee, not a worker, an employee on grounds related to trade union membership activities.
So where are we?
At page 307 in the electronic bundle. Subsection 1, for the purposes of Part 10 of the Employment Rights Act, unfair dismissal, the dismissal of an employee shall be regarded as unfair if the reason for it, or if more than one, the principal reason, was that the employee, and then B, has taken part or proposed to take part in the activities of an independent trade union at an appropriate time. So there we have the twin provisions dealing with detriment or dismissal for participating in strike in activities of trade union at an appropriate time. I then turn to the provisions in this same Act which provide protection in respect of strike action. And the first of those is section 219, which is electronic bundle page 335.
This is in part 5, is it?
This is now, we are now in part 5, my lord. Yes, because the provisions we've just looked at were in part 3.
Yes.
So we're now in part 5 of the 92 Act.
And the page reference again?
Is 335. 219, protection from certain tort liabilities. An act done by a person in contemplation or furtherance of a trade dispute is not actionable in tort on the ground only, A, that it induces another person to break a contract or interferes or induces another person to interfere with its performance, or B, that it consists of his threatening that a contract will be broken or its performance interfered with, or that he will induce another person to break a contract or interfere with its performance. So the primary protection in respect of strike action is the immunity from tort, which has its origins in the Trade Disputes Act 1906. It's an immunity which applies both to unions and to workers, applies to any person, but that is the primary and important protection from legal liability in respect of strike action, which is at the heart of Part 5 of the 92 Act. Note that the immunity does not extend to breaches of contract, nor to breaches of disciplinary rules. It is an immunity only in respect of the economic torts. We then come to the more limited protections in respect of dismissal for participating in industrial action. And the first of those is at section 237, which is at page 385 of the electronic bond.
Page
385, my lord. So under section 237, an employee has no right to complain of unfair dismissal. At the time of his dismissal, he was taking part in an unofficial strike or other unofficial industrial action. And essentially, that is a strike which has not been authorised by a trade union unless the participants in the strike, none of them are members of a trade union. But that's the first provision. So that's an exclusion of protection in respect of unofficial action. We then have at page 387, section 238 of the 92 Act, dismissals in connection with other industrial action. This section applies in relation to an employee who has a right to complain of unfair dismissal and who claims to have been unfairly dismissed, where at the date of the dismissal, A, the employer was conducting or instituting a lockout, or B, the complainant was taking part in a strike or other industrial action. In such a case, an employment tribunal shall not determine whether the dismissal was fair or unfair unless it is shown that one or more relevant employees of the same employer have not been dismissed, or B, that the relevant employee has, before the expiry of a period of 3 months beginning with the date of dismissal, been offered re-engagement and the complainant has not been offered re-engagement. And to see how this fits in with the following section at subsection 2B, subsection D does not apply in relation to an employee who's regarded as unfairly dismissed by virtue of section 238A below. So there we have a limited exclusion of the unfair dismissal legislation where there is universal dismissal without selective re-engagement of striking workers. This will apply. And then finally, at page 389, we have section 238A, participation in official industrial action. Subsection 1, for the purpose of this section, an employee takes protected industrial action if he commits an act which, or a series of acts, each of which he is induced to commit by an act which, by virtue of section 219, is not actionable in tort, i.e. a strike to which the statutory immunity applies. And as my learned friend has observed, that requires that the balloting and notice provisions are complied with. 2, an employee who's dismissed shall be regarded for the purposes of Part 10 of the Employment Rights Act 96, unfair dismissal, as unfairly dismissed if the reason, or if more than one, the principal reason for the dismissal is that the employee took protected industrial action, and then where the protected industrial action was a strike relating to provision of a relevant service, the employee was not of an identified worker in relation to that strike, or was an identified worker in relation to the strike and did not take part in the strike except to an extent that complied with the work notice. I'll explain this in a moment. And then at 3, this subsection applies to a dismissal if the date of the dismissal is within the protected period. And the protected period is the 12-week period that has been discussed. As my learned friend has pointed out, that is subject to various modifications, and in particular, it may be extended if any period of the 12 weeks the employee is locked out. It may be extended if the dismissal takes place after the end of the protected period, but the employee has stopped taking protected industrial action. And it may be extended in addition where the period where the employees failed to take reasonable procedural steps to resolve the dispute. But subject to those adjustments, the effect of this is that if an employer waits till industrial action has been going for at least 12 weeks, then they may dismiss, and the automatic unfair dismissal procedures provisions don't apply. The reference to identified workers is a reference to the very recent amendment of this section by the Strikes Minimum Service Levels Act 2023. And the court will see at subsection 9, identified worker in relation to a strike relating to provision of a relevant service means a person who is identified in a work notice given in accordance with section 234C relating to the strike and before any day on which the work notice requires the person to work is given by the employer, etc. In broad terms, under the 2023 legislation, in certain identified sectors, the Secretary of State has made regulations saying that employers may give minimum service level notices which specify identified workers who must not strike. And if you are one of those identified workers, you cannot enjoy the protection of this section. Nothing turns on that directly for our purposes. The reason that I highlight that is it shows just how finely calibrated the rights relating to dismissal for taking strike action are. And indeed, they have been amended in a material way just this year. And I make the point that all of that finely calibrated legislation, on my learned friend's case, must be incompatible with Article 11. And I say that for a reason really arising from a question my Lord Richards asked a moment ago of my learned friend. The appellant's case is that any detriment against a striking worker is ipso facto a breach of Article 11 if there is no statutory protection. That is his case. He describes it as a hard-edged rule, a hair-trigger rule, he describes it as. If that is right, any dismissal of a striking worker, which is unprotected, must involve a breach of Article 11, because a dismissal is, on any view, detrimental. So, my learned friend isn't merely, as it were, attacking Section 146 and 152 in this case. He is attacking all of these carefully calibrated provisions relating to dismissal for participating in strike action. So we submit that the key points arising from the history of the legislation, which I've taken a little bit of time on, but it seems to us it's worth doing so. We can take these 3 points from the legislation. First, it is clear that the protection relating to participation in trade union activities at an appropriate time is considered by Parliament to be separate and distinct from the more limited protections applying to those participating in industrial action. That is the only sensible and rational explanation of the history of the legislation and the scheme of the 92 Act in parts 3 and 5.
Can you just say protection for taking part in union activities at an appropriate time, and then how do you...
Has been considered by Parliament to be separate and distinct from the more limited protections applying to those participating in industrial action. That, we submit, is the only sensible and rational explanation of the history and the division of labour, if I can call it that, between Part 3 of the 92 Act and Part 5. Secondly, we submit that since their inception in 1971, over 50 years ago, Sections 146 and 152 have followed a parallel course. They are, as we describe them, sibling provisions. Children of the same parent have coexisted, save for the 1 year interregnum from 1974 to 5, where they were reintroduced in 2 pieces of legislation. And therefore, we do submit that Mr. Justice Chowdhury's finding in the EAT, for your note at paragraph 81A, electronic bundle, page 214, his finding that the provisions developed separately is not correct. They've in fact developed in close parallel and been treated by Parliament as complementary in nature. Thirdly, while Parliament has consistently provided protection to those participating in trade union activities at an appropriate time, the protection afforded to those participating in industrial action has been much more variable and limited. Historically, the employer has retained a right to dismiss striking workers, although the conditions for doing so have varied. Despite having had many opportunities to do so, however, Parliament has never legislated in all these industrial relations acts, it's never legislated to prohibit detriment, short of dismissal, against striking workers. Now, it's not surprising that the law in this area has varied. The law relating to industrial action is highly contested from a political and social perspective. There have been swings in different directions, from the initial legislation from the 70s to the more restricted approach in the 1980s, of the Thatcher government to the more expansive approach introduced by New Labour, and the pendulum perhaps swinging back the other way with the Strikes Minimum Service Levels Act this year. But we submit that's not surprising, because industrial action brings the economic rights of employers into direct conflict with those of workers. And different governments have taken different views on precisely where the balance should lie. By contrast, the protection of trade union activities at an appropriate time is much less controversial. We submit that it's a basic adjunct of the right of freedom of association, and the condition as to timing ensures that it will not be unduly disruptive of the employer's operation.
But strikes that go on for up to 12 weeks are highly disruptive.
Precisely, and that's why I'm drawing this distinction.
The protection there, you say it's more limited, but in that context, it's much more generous than for participation in union activities.
Yes, in
I
that.
mean, I appreciate there's a distinction. That's absolutely clear. But I think 2 or 3 times you've said that you've contrasted Section 146 with the more limited protection in relation to unfair dismissal for taking part in a strike. But it's not.
Well, my Lord,
it's much broader.
My Lord, it is because of Section 152. Section 152 means it is always unfair to, if we could just return there, it's at it's at page 307 in the electronic bundle. So for the purposes of Part 10 of the Employment Rights Act 1996, unfair dismissal, the dismissal of an employee shall be regarded as unfair if the reason for it was that the employee has taken part.
Yes, but I know, but it's very limited because it's all about what can be done at an appropriate time. And that's why I'm saying that in relation to strikes that go on for up to 12 weeks, there's much broader protection.
Well,
Maybe it's a different way of putting the point, but I just was puzzled by you saying it was a more limited protection in relation to striking employees.
Well, in my submission for this reason, that the effect of Section 152 is that dismissal for participating in union activities at an appropriate time.
Yeah, in your own time or at a time agreed with an employer.
That will always be an unfair dismissal.
All right. Well,
Yes, I think I see the point that's being made. The point that I'm trying to make, my Lord, is that where one is dismissed for striking, there isn't universal protection. That's as high as I put it. Perhaps I've over-egged the
there aren't
point.
many strikes that go on for more than 12 weeks.
No, I think it's fair to say that at the time when this legislation was first enacted, there were far more.
Yes.
Turning then to the Strasbourg jurisprudence, as I've noted, the appellant puts her case in categorical terms. Her case is that the authorities speak with one clear voice and that any sanction imposed on a worker for participating in industrial action gives rise to a breach of Article 11. The appellants describe this as a hair-trigger test at paragraph 35 of their case, where no margin of appreciation applies. And for reasons that I hope to elucidate, we submit that the Strasbourg court has not gone nearly that far. Before getting into the authorities themselves, I would make the following general observations about the Strasbourg jurisprudence. The European Court of Human Rights doesn't, we submit, generally deal in hard-edged principles or bright-line rules. One has to look at the developing underlying principles which arise from each case being closely focused on its own facts, with the court very much focusing on the substance of any interference rather than the form. And following on from that, what we say is that the cases from Strasbourg show that there are essential elements, and I'll come to the phraseology in a moment, but there are essential elements where the court is highly protective of trade unions and their members. And then there's a sort of penumbra or a borderline where the protection is reduced and the margin of appreciation is wider. And I will seek to make that good by reference to specific authorities in a moment. But various terms are used to describe this distinction. Essential in some cases, fundamental is the word used, I think, in Straum. Core aspects is another phrase used, and also primary and secondary aspects. Now, if you read all of these phrases arising in the Strasbourg jurisprudence, our submission is that they are effectively interchangeable. And what the court is driving at is that there are certain areas of protection where there is a high level of protection and a very reduced margin, and then there are more peripheral areas of protection where it will be much more fact-dependent, and in particular where the state has a much wider margin of appreciation. So that's our first general observation on the Strasbourg jurisprudence. Secondly, we submit that if one looks at the cases where Article 11 has been found to be breached, broadly they cover three scenarios. First, there are cases such as Demir, where the state has directly intervened to prevent collective bargaining, voluntary entered into between consenting parties. That's the first category. Secondly, there are cases such as Wilson, Danilenkov, and Tek-Gida.
Sorry, Wilson.
Wilson, Danilenkov, and Tek-Gida, where there's been victimization of those who wish to engage in collective bargaining or other trade union activities, which has enabled the employer to shut out the union, and thus effectively defeating its right to seek to persuade the employer on behalf of its members where the state has not provided adequate protection. That's the second category. And the third category are the cases such as Ezelin and the cases that have flowed from that, where the state itself has directly imposed sanctions on individuals in breach of their right of freedom of association.
Sorry, the third category again.
The third category is the cases such as Ezelin, Karakay, and so on, where the state itself has directly imposed sanctions on individuals when they've exercised their right to freedom of association. Common to all three categories we submit is the Strasbourg Court's characterization of the essential element of Article 11 as being to protect the individual from arbitrary interference by public authorities in the exercise of their rights. So with that preamble, I propose to go to the authorities, or at least some of them now, and I propose to deal with them under three headings. First, I'd like to go to the authorities which deal with the Strasbourg Court's general developing approach to Article 11. Secondly, we'll look at the cases dealing with direct interference by the state with Article 11 rights, most of them from Turkey. And thirdly, I'll consider the cases which are cited by the appellant involving private employers, none of which in our submission are cases about the right to strike, but on analysis are cases about union membership and the right to be heard. So that's the order. Before doing so, it would be remiss not to go to this court's judgment in Deliveroo, which did contain a very extensive analysis of Article 11. That case was concerned with a different aspect, the collective bargaining right, as well, I'm sure all of the court knows, but in particular my Lords Lloyd Jones and Richards. But in my submission, some key principles were distilled from that. This is in the supplemental authorities bundles, which is a function of just how hot off the press it is. At tab 3, page 11 of the supplemental bundle, we see the Deliveroo judgment. The question there being whether the Deliveroo riders who did not have worker status had their Article 11 rights breached because they were precluded under the legislation from seeking recognition for collective bargaining purposes. Now, at page 25, paragraph 37, my Lord Lloyd Jones and Lady Rose, who gave the judgment said this. Article 11.1 confers a number of different freedoms. In addition to a general freedom of peaceful assembly and a general freedom of association with others, Article 11...
I'm sorry, paragraph?
Paragraph 37.
37.
My Lord, page 25 of the supplemental electronic bundle.
Thank you.
In addition to a general freedom of peaceful assembly and a general freedom of association with others, Article 11.1 confers a trade union freedom which applies in more limited circumstances. As a result, the trade union freedom may be regarded as a specific subset of the general freedom of association. Furthermore, the content of the trade union freedom has not remained a constant, but has expanded by interpretation of the Strasbourg Court. Of particular significance in the present case is Demir in Turkey, where the Strasbourg Court acknowledged for the first time that the trade union freedom includes a right to bargain collectively. And then at paragraph 90 of the judgment, which is page 46, this is said: the right of workers that the union to which they belong should be heard is the vehicle through which the law has developed. And in our submission, that is a key sort of finding to understand the nature of the Article 11 right. If we go on to paragraph 97, the way it's put there, and this is dealing with Demir, where the Turkish state had refused to recognise.
Sorry, can you give me the paragraph?
Paragraph 97, page 48. This is dealing with Demir, where Turkey refused to acknowledge or recognise a collective agreement freely entered into. It says, turning to the Turkish state's non-recognition of Mr. Demir's union, the court said at paragraph 110 that the essential object of Article 11 is to protect the individual against arbitrary interference by public authorities with the exercise of the rights protected. And that is, we submit, the essence of the Article 11 right. And what we see is the court then went on to consider, in particular, the case of Unite the Union and United Kingdom, which was concerned with the abolition of the Agricultural Wages Board. And in that case, this court rejected the union's argument that Unite the Union should be read as establishing a right to compulsory collective bargaining. And the key passages are paragraph 129, which is supplemental bundle page 60. The court reiterated at para 55 of Unite the Union that in view of the sensitive character of the social and political issues involved in achieving a proper balance between the respective interests of labour and management, and given the high degree of divergence between the domestic systems in this field, the starting point is that contracting states enjoy a wide margin of appreciation as to how trade union freedom and protection of the occupational interests of trade union members are secured. And we very much pray that in aid. By stating at para 63 that the margin of appreciation to be applied is accordingly a wide one, the court was confirming that nothing has changed. It's certainly not taking the step forward on which the union relies in this appeal. And on the basis of that, at paragraph 134 in Deliveroo, page 62, this court said, in our judgment, therefore, the court in Unite the Union did not develop the law beyond what had been decided in Demir and Wilson, and did not decide that Article 11 now includes a right to compulsory collective bargaining, insofar as the domestic case law has interpreted the Strasbourg authorities to the contrary. Those decisions should not be followed. And therefore, this court overruled previous Court of Appeal decisions, in particular in Boots Management Services and Independent Workers of Great Britain, which had indicated that Article 11 might entail a right to compulsory collective bargaining. This court held Strasbourg had not gone so far. And we say that if one takes nothing else from Deliveroo, we submit it stands as a warning against too expansive, prescriptive and hard-edged an interpretation of Article 11. But turning then to the Strasbourg authorities And I'll commence my canter through those today, but we'll obviously need to go into tomorrow to do justice to them. I'd like to start pretty much where my learned friend did, with Wilson and United Kingdom, which is at tab 33, page 1170. So Wilson was the case where the applicant was a journalist on the Daily Mail. The employer had de-recognised the union and offered financial incentives to those who agreed to the de-recognition and who agreed to sign new contracts. And nothing in the domestic law had prevented them from doing that. What we see at paragraphs 27 to 28 at page 1174 is this. Section 23 of the Employment Protection Consolidation Act 1978 provided, every employee shall have the right not to have action short of dismissal taken against him as an individual by his employer for the purpose of preventing or deterring him from seeking to become a member of an independent trade union or penalising.
Sorry, which paragraph?
Paragraph 27.
27, thank you.
And that was the provision that was reenacted at section 146 of the 92 Act. And then we see this at 28. After the Court of Appeal found for the applicants, Parliament enacted section 13 of the Trade Union Reform and Employment Rights Act 93 to amend section 148 of the 92 Act by providing that where the employer's purpose was to further a change in his relationship with all or any class of employees, then unless the employer's action was action that no reasonable employer could take, section 146 of the 92 Act would provide no remedy for the employee. And what was perhaps so egregious about Wilson then was that the Court of Appeal held the employee was protected. And so what Parliament did in response to that was to enact new legislation specifically providing that employer was able to offer incentives, financial incentives to its employees to bring to an end collective bargaining. That was the nature of the case. And we see at paragraph 41, at page 1176, the court observes at the outset that although the essential object of Article 11 is to protect the individual against arbitrary interference by public authorities with the exercise of the rights protected, there may in addition be positive obligations to secure the effective enjoyment of those rights. So that was the principle that was being applied, and we see over the page at paragraph 44, page 1177, however, the court has consistently held that although collective bargaining may be one of the ways by which trade unions may be enabled to protect their members' interests, it is not indispensable for the effective enjoyment of trade union freedom. Compulsory collective bargaining would impose on employers an obligation to conduct negotiations with trade unions. The court has not yet been prepared to hold that the freedom of trade union to make its voice heard extends to imposing on an employer an obligation to recognise a trade union. The union and its members must, however, be free in one way or another to seek to persuade the employer to listen to what it has to say on behalf of its members. In view of the sensitive character of the social and political issues involved in achieving a proper balance between the competing interests, the wide degree of divergence between domestic systems in this field, the contracting states enjoy a wide margin of appreciation as to how trade union freedom may be secured. See Swedish engine drivers. So there the court emphasised the sensitive character of the social and political interests and therefore the wide margin of appreciation. And then it concluded at paragraphs 47 and in particular at 48, under United Kingdom law at the relevant time, it was therefore possible for an employer effectively to undermine or frustrate a trade union's ability to strive for the protection of its members' interests. The court notes that this aspect of domestic law has been the subject of criticism, etc. It considers that by permitting employers to use financial incentives to induce employees to surrender important union rights, the respondent state failed in its positive obligation to secure the enjoyment of the rights under Article 11. And therefore, there was found to be a breach of the positive obligation. But in our submission, what is key to this and what is notable is that the substance of this case was it was a shutting out of the union's right to be heard. And that, as we shall see, is plainly one of the essential elements of Article 11, indeed what many of these cases ultimately are about. And we see that next in Demir and Turkey. The interference there, as I've noted, was the annulment of a collective agreement between a civil servants' trade union and a municipal council, with the court finding that civil servants were precluded from entering into collective agreements and then, for good measure, dissolving the trade union. This was described in Deliveroo as an egregious set of factors, and in RMT as a very far-reaching interference with freedom of association that intruded into its inner core. And the Grand Chamber, which was the court, the makeup of the court in that case, commented generally on the development of Article 11 at paragraph 143 onwards. That's at page 914 of the electronic bundle.
Paragraph again, please.
It's paragraph 143, page 914, my lord.
Thank you.
It says, subsequently, in the case of Wilson, the court considered that even if collective bargaining was not indispensable for the effective enjoyment of trade union freedom, it might be one of the ways in which trade unions could be enabled to protect their members' interests. The union had to be free in one way or another to seek to persuade the employer to listen to what it has to say on behalf of its members. And just pausing there, you'll note the reference to there being different ways of seeking to pursue the members' interests, and the freedom only requiring that one of those ways ought to be open. And then at 144, it says, as a result of the foregoing, the evolution of case law as to the substance of the right of association enshrined in Article 11 is marked by two guiding principles. Firstly, the court takes into consideration the totality of the measures taken by the state concerned in order to secure trade union freedom, subject to the margin of appreciation. And pausing there, I will be submitting in due course that if one sees the current legislation in all its aspects and takes it all into account, it cannot be said that the current statutory protections fall outside the wide margin of appreciation that applies. The court then goes on at paragraph 144. Secondly, the court does not accept restrictions that affect the essential elements of trade union freedom, without which that freedom would become devoid of substance. These two principles are not contradictory but are correlated. This correlation implies that the contracting state in question, which in principle, whilst in principle being free to decide what measures it wishes to take in order to ensure compliance with Article 11, is under an obligation to take account of the elements regarded as essential by the court's case law. From the court's case law as it stands, the following essential elements of the right of association can be established: the right to form and join a trade union, the prohibition of closed shop agreements, and the right for a union to seek to persuade the employer to hear what it has to say on behalf of its members. So those are the essential elements. It goes on to say the list is not finite. On the contrary, it is subject to evolution depending on particular developments in labour relations. In this connection, it's appropriate to remember that the Convention is a living instrument which must be interpreted in light of present-day conditions. and so as to reflect the increasingly high standard being required in the area of protection of human rights. So it's evolving, and the key step in Demir was that it was accepted that a right to collective bargaining, or more accurately, a right in that case not to be prevented from collective bargaining, fell within the ambit of Article 11. Because what the court said at paragraph 154 was that consequently, the court considers that having regard to the developments in labour law, both international and national, and to the practice of contracting states in such matters, the right to bargain collectively with the employer has in principle become one of the essential elements of the right to form and join trade unions for the protection of interests under Article 11. So that was the step change in Demir. And therefore, the annulment, we see at 169, the annulment ex tunc of the collective agreement amounted to a breach. The next case dealing with the general development of Article 11 is the Good Shepherd case, which is at tab 29, page 1083. Now, this was a case, another decision of the Grand Chamber concerned with whether it was a breach of Article 11 for Orthodox priests in Romania to be prevented from forming trade unions. Again, quite a fundamental inference, although there was found to be no violation of Article 11 in that case. And we see the relevant principles at paragraph 131 of that judgment, which is at page 116.
Page what?
No.
Page 1116.
1116.
1116, paragraph 131. Or in fact 130. The court observes at the outset, having regard to the developments in international labour law, that trade union freedom is an essential element of social dialogue between workers and employers, hence an important tool for achieving social justice and harmony. It further reiterates Article 11 presents trade union freedoms as a special aspect of freedom of association, and that although the essential object of that article is to protect the individual against arbitrary interference by public authorities, there we have that statement again, with the exercise of the rights it protects, there may in addition be positive obligations on the state to secure the effective enjoyment of such rights. The boundaries between the state's positive and negative obligations under Article 11 do not lend themselves to precise definition. The applicable principles are nonetheless similar. Whether the case is analysed in terms of a positive duty or in terms of interference by the public authorities which need to be justified, the criteria to be applied do not differ in substance. In both contexts, regard must be had to the fair balance to be struck between the competing interests of the individual and of the community as a whole. In view of the sensitive character of the social and political issues involved in achieving a proper balance between the respective interests of labour and management, and given the high degree of divergence between the domestic systems in this field, the contracting states enjoy a wide margin of appreciation as to how trade union freedom and protection of occupational interests of union members must be secured. Pausing there, my lords, my lady, it's very important we say that the court is here talking in terms of the respective interests of labour and management, because it is there acknowledging these often diametrically opposed interests between employers on the one hand, who have their rights, and workers on the others. And it is in that context that it refers to the wide margin of appreciation that applies. We come finally then, I suspect for today, to the RMT case. And that is the next case on the general development of Article 11. It's tab 28, page 1061. That was concerned with a complaint to Strasbourg from the RMT. One was that the notice requirements relating to strike ballots were said to be a breach of Article 11. That complaint was ruled inadmissible because not least it had been possible ultimately to comply with the provisions. And the second was the blanket restriction on secondary action. And on that complaint, the analysis is at paragraphs 84 onwards. You have already been taken to this, but this is an important authority, and if I may take you back to that, it's at page 1075.
The first head of complaint again was?
The first complaint was that the balloting and notification requirements under the 1992 Act, which apply to strike action, was said to be so onerous
Yes.
as to breach Article 11.
Yes.
That was held to be inadmissible, so ruled out, sort of, as it were, in limine. The second complaint was as to the blanket ban on secondary action.
Thank you.
And so we pick it up again at paragraph 84, and there it says the court will consider first the applicant's argument that the right to take strike action must be regarded as an essential element of trade union freedom under Article 11. One sees then there's reference to a number of authorities, and what the court says in the concluding sentences. It should be noted that the judgment was here advertising the position adopted by the supervisory bodies of the ILO rather than evolving the interpretation of Article 11 by conferring a privileged status on the right to strike. More generally, what the above-mentioned cases illustrate is that strike action is clearly protected by Article 11. The court, therefore, does not discern any need in the present case to determine whether the taking of industrial action should now be accorded the status of an essential element of Article 11 guarantee. And in our submission, it is very clear that the court is there declining to hold that the right to take strike action is an essential element of Article 11. It is merely acknowledging that the right to strike may be protected under Article 11 in some circumstances. We then have paragraphs 86 to 88, which really are at the core of the, in fact, to 89, which are at the core of the court's reasoning. In previous trade union cases, the court has stated that regard must be had to the fair balance to be struck between competing interests of the individual and of the community as a whole. And then this, since achieving a proper balance between the interests of labour and management involves sensitive social and political issues, the contracting states must be afforded a margin of appreciation. So again, where one has intention, employers' rights and workers' rights, there one has to afford a wide margin of appreciation. They go on to say, in fact, that in the most recent restatement of the point and referring to the high degree of divergence, it observed between domestic systems and the field, the Grand Chamber considered the margin should be a wide one. The applicant relied...
Sorry, where are you reading from?
Sorry, from 86, about 10 lines down. Should be a wide one. The applicant relied heavily on the Demir judgment, in which the court considered that the respondent state should be allowed only a limited margin. The court would point out, however, that the passage in question appears in the part of the judgment examining a very far-reaching interference with freedom of association, one that intruded into the inner core, namely the dissolution of a trade union. And there you see this substantive approach that the court adopts. That case was concerned with a consensual collective agreement which was struck down by the state and the union dissolved. That was said to go to the inner core of the right to a freedom of association for obvious reasons, because the state in that case was saying, you can't have a trade union and you can't enter into collective agreements. That's why it was an inner core case, and that's why the margin of appreciation in that case was a correspondingly narrower one. It is not to be understood as narrowing decisively and definitively the domestic authorities' margin of appreciation in relation to regulating through normal democratic processes the exercise of trade union freedom within the social and economic framework of the country concerned. The breadth of margin will still depend on the factors that the court in its case law has identified as relevant, including the nature and extent of the restriction on the trade union right at issue, the object pursued by the contested restriction, and the competing rights and interests of other individuals in society who are liable to suffer as a result of the unrestricted exercise of that right. The degree of common ground between member states of the Council of Europe in relation to the issue may also be relevant. Then at 87, if a legislative restriction strikes at the core of trade union activity, a lesser margin of appreciation is to be recognised. And then at 88, as to the nature and extent of the interference suffered in the present case, the applicant, in the exercise of its trade union freedom, the court considers that it was not as invasive as the applicant would have it, and it sets out its reasons why. And over the page, at the top, it says, on this ground, the case is to be distinguished from those referred to in paragraph 84 above, which all concerned restrictions on primary or direct industrial action by public sector employees. And the margin of appreciation to be recognised to the national authorities is the wider one available in relation to the regulation of the public interest of the secondary aspects of trade union activity. Now, we submit, if one looks back to paragraph 84, that is a reference to the line of public sector cases that my learned friend relies on. So it's a reference to Karakay, Dilek, Erkan, Energy, Yapi Sol, Senan, Turkey. That whole line of cases are distinguished. And they are distinguished on two bases. One is that they was involved in primary rather than secondary action, but also expressly on the basis that it was involving public sector employers. And in my submission, that is wholly unsurprising, given the repeated references by the Strasbourg Court to Article 11 being about preventing arbitrary interference by the state in the enjoyment of the Article 11 right. Because where you're dealing with public sector employees, the state is directly penalising them. It is action by the state. Where one is dealing with the private sector, one has the state acting as a referee, as a sort of arbiter between the economic rights of two groups in society, employers and employees. It's doing a very, very different exercise when it's trying to juggle or balance the rights of two groups of private citizens. In all of those cases referred to in paragraph 84, that wasn't what was being done, because it was the state itself that was interfering. The state was imposing the interference. And so finally, at 89, as for the object of the interference in issue, in the present case, it refers to the debates in Parliament, and it says that assessment was sharply contested at the time by the opposition and is rejected by the applicant as grounded in animus towards trade unions rather than any clear evidence of direct damage to the economy. Yet the subject matter in this case is certainly related to the social and economic strategy of the respondent state. In this regard, the court has usually allowed a wide margin of appreciation, since by virtue of their direct knowledge of their society and its needs, the national authorities, and in particular the democratically elected parliaments, were in principle better placed than the international judge to appreciate what is in the public interest on social and political grounds. And so we pray that in aid where this is a sensitive political issue, where Parliament is seeking to balance the interests of different groups. The European Court of Human Rights couldn't be clearer here that is where you apply a very wide margin of appreciation, and that is precisely the area we are in this case. My lords and my lady, I see the time. Would that be a convenient moment?
Point at which to leave it. Thank you very much. We'll resume tomorrow morning at 10:30, and we're due to finish, I think, at 1 o'clock.
Yes.
Thank you both very much indeed. We'll resume tomorrow morning at 10:30.